the government matter.
But yesterday itself we have filed the reply on this.
क्या है?
Yes, Your Lordship. Your Lordship, there was an incident happened on 7/1/2023 when in the midnight at 3 a.m. the petitioner went on the stage and abused filthy words towards the Honorable Chief Minister of Madhya Pradesh matter. So against that, subsequent thereto, multiple FIRs have been registered on account of that incident
जी
at different police stations across Madhya Pradesh. So we have come before the Honorable High Court simply that all the FIRs should be clubbed because it is arising out of
ठीक
same
है,
incident.
सेम इंसिडेंट में तो क्लब तो होंगी।
सर इसमें हमने ऑब्जेक्शन लिया, प्रिलिमिनरी
हाँ
ऑब्जेक्शन
बताइए।
कि at the stage of investigation the petitioner has no right to
नहीं, ही इज ओनली सीकिंग दैट एक इंसिडेंट के कारण आपने जगह जगह पर एफआईआर दर्ज करा दी, तो एक जब इंसिडेंट है
जी
तो आप क्लब करके इन्वेस्टिगेट कर लीजिए, वो यही तो कह रहे हैं। अगर अलग अलग घटना होती, जैसे अभी उन्होंने आपको गाली दी
जी
तो एक घटना हो गई, एक उन्होंने आपको कल गाली दी थी वो एक दूसरी घटना हो गई, एक शाम को गाली देंगे वो तीसरी घटना हो जाएगी। बट एक ही गाली के लिए आप अलग अलग एफआईआर दर्ज करके अलग अलग इन्वेस्टिगेट करके क्यों उसको प्रताड़ित करना चाहते हैं?
Lordship, yes, Lord.
Hmm.
Lordship, this is a case of flagging of the FIRs. Reply is also received by the government matter.
but yesterday itself we have filed the reply on this.
क्या है?
Yes, Your Lordship. Your Lordship, there was an incident happened on 7/1/2023 when in the midnight at 3 a.m. the petitioner went on the stage and abused filthy words towards the Honorable Chief Minister of Madhya Pradesh matter. So against that, subsequent thereto, multiple FIRs have been registered on account of that incident
जी
at different police stations across Madhya Pradesh. So we have come before the Honorable High Court simply that all the FIRs should be clubbed because it is arising out of
ठीक
same
है,
incident.
सेम इंसिडेंट में तो क्लब तो होंगी।
सर इसमें हमने ऑब्जेक्शन लिया, प्रिलिमिनरी
हाँ
ऑब्जेक्शन
बताइए।
कि at the stage of investigation the petitioner has no right to
नहीं, ही इज ओनली सीकिंग दैट एक इंसिडेंट के कारण आपने जगह जगह पर एफआईआर दर्ज करा दी, तो एक जब इंसिडेंट है
जी
तो आप क्लब करके इन्वेस्टिगेट कर लीजिए, वो यही तो कह रहे हैं। अगर अलग अलग घटना होती, जैसे अभी उन्होंने आपको गाली दी
जी
तो एक घटना हो गई, एक उन्होंने आपको कल गाली दी थी वो एक दूसरी घटना हो गई, एक शाम को गाली देंगे वो तीसरी घटना हो जाएगी। बट एक ही गाली के लिए आप अलग अलग एफआईआर दर्ज करके अलग अलग इन्वेस्टिगेट करके क्यों उसको प्रताड़ित करना चाहते हैं? उसका प्रोविजन क्या है बताइएगा कानून में?
सर ये रिपोर्ट में जो है इस बात का उल्लेख है कि
किस पेज
7
पे पढ़ रहे हैं?
7 एवं 8 पेज 26
पेज 26
ये FIR
आपके जवाब के?
नहीं सर, ये पिटीशन के पेज 26 ये FIR का अरेंजमेंट कर रहा हूँ कि एक घटना नहीं है ये।
किसका? अरे अपीयर तो हो रहे हैं, किसको नोटिस जाना था?
Lordship, notices were directed to be issued, but reply is already received, sir. Lordship. That is, no more are required.
बोलिए क्या है?
सर पेज 26 में
पेज
दिसी
26 पढ़िएगा
जी FIR। मैं थाना पिपलानी में सहायक उप निरीक्षक पद पर पदस्थ हूँ। थाना पिपलानी में पदस्थ प्रधान आरक्षक इतना धनेंद्र मिश्रा ने रिपोर्ट आकर दर्ज कराया कि 7/1/2023 एवं 8/1/2023 के मध्य में करणी सेना टीम जीवन शेरपुर धरना प्रदर्शन जम्बूरी मैदान में चल रहा था। उक्त धरना प्रदर्शन में उप निरीक्षक KP सिंह के साथ रवाना किया गया। जम्बूरी मैदान मंच के पास पहुंचा तो मंच पर एक युवक उपेंद्र सिंह राणा निवासी भिवानी का जो पीला कुर्ता सफेद पजामा काली जैकेट पहने हुआ था तथा दाढ़ी रखे हुआ था, माइक पर माननीय मुख्यमंत्री श्री शिवराज सिंह चौहान को शिवराज सिंह मामा ये का नारा लगाते हुए अश्लील गालियां दे रहा था।
नहीं हूँ, आपका राइट है इन्वेस्टिगेट
सर
करना
सर सर
और इस तरीके की घटनाएं नहीं होना चाहिए। देखिए इशू ये है कि एक घटना, ये क्या कह रहे हैं, 7 और 8 की मिडनाइट उस जम्बूरी मैदान में
जी
एक घटना हुई।
जी
कैन यू लॉन्च मल्टीपल FIR? उसमें ये भी नहीं लिखा दैट इट वाज बीइंग ट्रांसमिटेड थ्रू ऑडियो विजुअल मीडिया टू डिफरेंट प्लेसेस, ये भी नहीं है FIR में। हाँ बताइए क्या प्रोविजन है क्लब की?
Yes, Lord, I am relying upon this judgment of the Honorable Supreme Court of India.
जी
Lordship, para 23, 20, 22, 23 and 24, Your Lordship.
पढ़िए।
Lordship, in 22 paragraph, in Arnab Goswami versus Union of India, while dealing with the issue of multiplicity of proceeding and harassment to the accused, a two-judge bench of which Honorable one of us was part held that Article 32 of the Constitution constitutes a recognition of the constitutional duty entrusted to this court to protect a fundamental right of citizen, The exercise of well, that is the bold part is most important, Your Lordship. India's freedom will rest assured if long journalists can speak truth to power without their.
Are you a journalist?
No, no, I'm not a journalist, but Lordship, the law is on paragraph
Leader of
24.
Karni Sena.
24 is the relevant paragraph.
पढ़िए 24 पढ़िए.
Yes. As regards the prayer for questioning of the FIR, an essential aspect of the matter which must be noticed at this stage is that the investigation by the special cell of police, Delhi police and so and so pertains to offence of a cognate nature of those offences having marked in the FIR which have been lodged before the police station Uttar Pradesh. I'm leaving one paragraph, my lords. However, a fair investigative process would require that the entirety of the investigation and all the FIRs should be consolidated and entrusted to one investigating authority. The overlap in the FIRs emanating as they do not as do form from the tweets of the petitioner only goes to emphasize the need for a consolidated as opposed to the piecemeal investigation by a diverse set of law enforcement agencies.
जी.
Then, Your Lordships, this judgment, then another judgment in which the Honorable Supreme Court have clubbed the FIRs is N.V. Sharma, Your Lordships.
Yes.
And this is one more judgment, Your Lordships, Navika Kumar, in which also the Honorable Supreme Court has clubbed the FIRs. Paragraph 6, 7, 8
Yes,
are
yes.
relevant for this purpose, my lords.
बताइएगा. लिखिएगा. This petition is filed seeking a direction to club various FIRs which are being registered against the petitioner under section 294 and 34 IPC for an incident which took place on 8/1/23 and for which report was received by the concerned police station on 10/1/23 at about 20:00 hours, registering FIR number 0030 of 23 at police station Piplani, district Bhopal. Full stop. It is submitted that petitioner is an activist of Karni Sena. Karni Sena के है ना आप?
Yes, my lord.
Karni Sena. Full stop. Because of political opposition to a particular to the other side of the ideology, petitioner has been framed in multiple FIRs. Full stop. It is submitted that बाकी FIR के नंबर कहाँ हैं?
Your lordship, all the FIRs have been placed as annexure. Annexure P1 is the first FIR.
हाँ
That is FIR 30 of 2023 before police station Piplani.
जी.
Second is FIR 60, crime number 60 of 2023 before before police station Selan, district Ratlam. Third is, my lords, 40 of 2023 before police station Piplani, Bhopal again. Fourth is, your lordships, before police station Misrod, district Bhopal. FIR crime number 18 of 2023. And your lordships, the last is FIR 10 of 2023 before police station Zirapur, district Rajgarh. These are the ones which I am aware of, your lordship.
It is submitted that for the same incident, multiple FIRs have been lodged, namely case crime number 60/23 at Selana, district Ratlam, case crime number 40 of 23 at police station Piplani, Bhopal, case crime number 18/23 at police station Misrod, district Bhopal, and case number 10/23 at Jirapur, police station Jirapur, district Rajgarh. Full stop. Next paragraph. Placing reliance on the judgment of Supreme Court in Mohammad Jubair versus State of NCT of Delhi and others, 2022 SCC online SC 897, and reading paragraph 22 and 24, it is pointed out that a fair investigative process, a fair investigative process would require that the entirety of the investigation in all the FIRs should be consolidated and entrusted to one investigating authority. Full stop. The overlap in the FIRs, emanating as they do from the tweets of the petitioner, only goes to emphasize the need for a consolidated, as opposed to piecemeal investigation by a diverse set of law enforcement agencies, full stop, inverted commas, close. Next paragraph. Similarly, reliance is placed on the judgment of Supreme Court in N.V. Sharma versus Union of India and others, 2022 SCC Online SC 1003, where Supreme Court held that all FIRs in Nupur Sharma Prophet remarks case be clubbed and should be tried by IFSO unit of Delhi Police. Full stop. Similarly, reliance is placed on the judgment of Supreme Court in Navika Kumar versus Union of India and others, 2022 SCC Online SC 1289, wherein again in the matter of Prophet remark case, it was directed that all the FIRs against the journalist be clubbed. Full stop. Placing reliance on these judgments, it is submitted that petitioner's case is similar. He has been falsely implicated. Next para. Shri Vivek Sharma, learned Deputy Advocate General for State, has filed his reply.
Paragraph
And-
3, 10 and
Eh?
this is the copy of reply, my lord, if my lord have
reply है ना इसमें ये
अच्छा, ठीक है.
paragraph number
Paragraph 3, 10 and 11.
full stop. It is submitted that in that paragraph 3, 10 and 11 are relevant for the purpose of the present controversy. Full stop. Next para. Reading from para 3 of the reply filed by the state government on 25 July 2023, comma, it is evident that a preliminary objection is taken in regard to maintainability of the petition. Full stop. It is submitted that at the stage of investigation, petitioner has no right to be heard. Full stop. To buttress their submission, reliance is placed on the judgment of Supreme Court in Narendra G. Goyal versus the State of Maharashtra, 2009 6 SCC 65. Full stop. It is submitted that it is held in the said judgment that accused has no right to be heard at the stage of investigation. Similarly, reliance is placed on the judgment of Supreme Court in case of Romila Thapar versus Union of India, 2018 10 SCC 754, wherein in para 30 it is mentioned that the accused cannot ask for changing the investigating agency or to do the investigation in a particular manner. Full stop. Similarly, in para 10 आपने 3 10
10 11 जी.
हाँ, in para 10 the stand is taken that
State of
the
MP.
present petition is devoid of merit and reliance is placed on the judgment of Supreme Court in State of Punjab versus Rajesh Syal, 2002 8 SCC 158, where Supreme Court held that different people have alleged to have been defrauded by the respondents and the company, and therefore each offense is a district one, full stop. District 1 and cannot be regarded as constituting a single series of facts object transaction, full stop. It will not be out of place to mention that the judgment has been quoted out of context in as much as the word distinct has been typed as district by the learned advocate who prepared the reply, full stop. In para 11, it is held that, again referring to Rajesh Syal judgment, it is pointed out that the judgment in case of V.K. Sharma was not a precedent and therefore same could not have been applied to the facts and circumstances of the present case. However, and moreover, that was overruled. And judgment of V.K. Sharma and P.K. Sharma were overruled. Next para. However, after hearing learned counsel for the parties and going through the record, certain facts are important to be mentioned. In the FIR which is filed along with the petition and as is read over by Shri Vivek Kumar Sharma, the Deputy Advocate General. Incident took place on 7/1/23 and in the intervening night of 7/1/23 and 8/1/23 when concerned Sub-Inspector ASI Ajay Kumar Nair had visited the Jamburi Maidan and identified the petitioner. Full stop. There are allegations that he was using abusive language against one of the public functionaries of the state. Full stop. Section 294. Full stop. FIR is registered under section 294 and 34 IPC. Full stop. Section 294 IPC deals with obscene acts and songs. Full stop. The punishment which is prescribed is 3 months or with fine or with both. The offense is cognizable, bailable but non-compoundable. Full stop.
सर इसके अलावा 153A 294 500 505 34
Full
भी
stop.
in other FIRs it is mentioned.
Other FIRs also reveal the same cause of action, a fact which is not disputed by Shri Vivek Sharma, learned Deputy Advocate General of the state. Full stop. When this aspect is taken into consideration, then the judgments which have been cited by the learned Deputy Advocate General are of no assistance. Full stop. The ratio in case of Narendra G. Goyal and Romila Thapar is twofold. Namely, there is no need to hear the accused at the time of investigation, and accused cannot ask for change of the investigating agency. Full stop. None of the prayer is to the effect to either give him an opportunity of hearing at the time of investigation or to change the investigation authority. Therefore, it is apparent that the state has failed to understand the pulse of the case. It has made generalized statement in para 3 of its reply. Prayer is only to club various FIRs. Full stop. Thus, the reply in para 3 is not relevant to the controversy involved, and thus the ratio of judgment laid down in case of Narendra Goyal and Romila Thapar will have no application to the facts of the present case. Next para. As far as his contention of the petitioner that in case of State of Punjab versus Rajesh Sayal, Supra, in para 7, Supreme Court has held that different people were alleged to be defrauded by the respondent and the company, and each of the offense is a distinct one and cannot be regarded as constituting a single series of facts, again reflects poor understanding of facts in the hand of the state. Full stop. In the present case, all the FIRs reveal the incident to be same which had taken place at Jamburi Maidan on the intervening night of 7th January 23 and 8th January 23. Full stop. Thus, when there is a single incident, then ratio of law laid down in case of Rajesh Sayal too will not be applicable, because in that case different persons were defrauded at different places, and therefore each of the complainant had a right to lodge FIR as per his individual transaction. Full stop. Therefore, I am of the considered view that taking this fact into consideration, that Honorable Supreme Court in case of Mohammad Jubair, Navika Kumar and N.V. Sharma has shown the indulgence of clubbing the various FIRs and has directed to carry out one single investigation and investigation, full stop. Honorable Supreme Court in Mohammed Jubair has made a clear observation in para 24 that such acts needs for a consolidated as opposed to piecemeal investigation by a diverse set of law enforcement agencies. Full stop. I am of the opinion that in view of the judgments of Honorable Supreme Court in Mohammed Jubair, Navika Kumar and N.V. Sharma, petitioner's case being on the identical footing, it is directed that state authorities may get the investigation carried out by any one of by any one of the investigators of their choice, but there will be a consolidated investigation in the matter of FIR registering case crime number 23 at PS Piplani and ये चार और FIR जो ऊपर लिखाई थी मैंने लिख लीजिएगा. Full stop. In the above terms, petition is disposed of. This court has not expressed any opinion on the manner or the methodology of investigation. It has only clubbed the FIRs and has directed for a single investigation.